Hereby advised of their duty under the State Government Ethics Act to avoid conflicts of interest and are instructed to refrain from participating in any matter coming before this committee with respect to which there is a conflict of interest. Does anyone have any conflicts they need to voice? Hearing none, we'll get started. The first order of business is everybody should have gotten or received and been able to review the minutes from our meeting back on March 27th. Does anyone besides Craig? Just so y'all know, Craig Lynch sent us some revisions or some corrections he saw. So I'll speak on his behalf a little bit since he's not here. But anybody have any specific corrections to the minutes? I will tell you that hearing none right now, Craig looked like 2 additions. I know, Brian, you had those earlier. It looks like about the 1, 2, 3, 4, about the 6th paragraph down, he added the words where it says supervised law practice for 18 months or until the announcement of the results of the first bar exam. That's splitting hairs to me, but whatever you see fit on that, it was fine the way it was worded for me. And then he also added at the end of the next paragraph, at the very end, for specified periods of time. I'm fine with those additions, but I'm fine with it the way it is. Anybody have any specifics? If not, anybody have a motion? Can I hear a motion to approve the minutes as written?
I need to unmute. So moved. I'll move.
Thank you, Jay. We have a second.
Second.
Thanks. All in favor? Aye.
Aye.
That's at least the 4 we got. So minutes have been approved. So we'll move on to the next section, which is basically going back through some of the proposal for the certification of law school graduates. There were some changes we made, so I'll turn that over to Brian and Peter as to the revisions that we have.
All right. And so, first of all, hello, everyone. Good to see y'all. And thank you to Lee and Billy and Nicoya for joining us. As you all may remember, at the conclusion of our last meeting, we were talking about, we've got this idea about creating new rules that would permit law school graduates to offer the same type of limited supervised practice as students do, particularly for those graduates that take the July bar exam after graduation, but are unsuccessful and not wanting to put them in the position, and of course the district attorneys, public defenders' offices, and legal aid offices that have maybe made offers to folks and they don't want to necessarily let those folks go. They can still do some sort of supervised practice. So that was kind of the goal here in creating these rules. But we wanted to talk to folks that would be impacted by this. And that's why I reached out to the Conference of District Attorneys, Conference of Public Defenders, and I know Nicoya had talked with Kevin before about this, so we could get their thoughts on how this rule needed? Would it be helpful? And ultimately, when we get down to some of the details of the rules and the practical application, do they have any sort of input here? So with that said, I'm gonna just share my screen, and we're gonna just briefly go over what changes were made from our last meeting. And you can see here, the first part was the same. The first change that we talked about was the definition of a certified law school graduate. And what we included in here was that the committee talked about wanting to know that the person intended to apply for the North Carolina State Bar. It wasn't simply just a graduate who was looking for certified practice, and maybe they weren't even going to apply for the bar exam until the following year. over in Virginia or California for that matter, but that this is somebody who is intending to become a part of the North Carolina State Bar, since this is the whole section is about the practical training of law students and the practical training really of the future lawyers of North Carolina. So it's intended to be something that somebody who plans to take the North Carolina State Bar can take advantage of. So we included this language that, the definition of a certified law school graduate is a law school graduate who has attested in writing that he or she intends to apply for admission to the North Carolina State Bar and is certified to work in conjunction with the supervising attorney and just kind of with the standard definition similar to what we have for student practice. I'm just going to briefly go over these different changes, and then we can kind of come back. So let me just give the overview first. As we go on, the next part that we were talking about was eligibility. What are the different standards that a law school graduate needs to meet, the different steps or requirements before they can actually apply for certification? Of course, with that background, and this is just the benefit for anybody who missed the meeting or for our new guests here today, we have that ability for students to get internships, externships, summer placements, all that kind of stuff, and provide these limited supervised legal services, which I'm sure you all have experienced in your different offices, whether it's during the semester or during the summer. And so, we're looking that in this particular situation, we're looking at a law school graduate. One of the components of the student certification is that the student is essentially kind of confirmed by the school that they are of good character, and they are, they're not somebody that the school would otherwise not recommend engage in this limited practice. That's not really applicable with the law school graduate. I think there's a presumption that we all felt comfortable with, that if somebody actually graduated from law school, that the school, may or may not know whether or not the person or should not have to attest to the person's character. But we did include some components to kind of address some of these different considerations. So yes, a law school graduate has to have graduated from an approved law school. Of course, this is the standard language of being introduced by an attorney that's admitted to practice in the tribunal or the agency where this graduate would appear before. We included that the graduate, to become a certified law school graduate and offer these limited services, they have to obtain a passing score on the MPRE. Also put in there that this person has not failed a character and fitness review that's been conducted by the Board of Law Examiners or any other professional licensing agency for that matter, because some folks will have an application for North Carolina at the same time that they're also applying for South Carolina, things of that nature. And that's one where I think we would address this by, yes, there's going to be a self-report, but also when a law school graduate applies for the certification, they would need to sign a waiver that permits us to speak with the licensing agencies to actually get that information, make sure that there's nothing that we just simply don't know about in terms of a failed character and fitness review. And then, of course, there's the standard things of that. This is the same language from the student requirements, but we do have them in two different sections. We have the first section, which is the one that everyone's familiar with as far as eligibility for a student, but we decided to make a separate section with regards to eligibility for a law school graduate. But these 2 points here were the ones that we added from our discussion last week. We also discussed duration. And this is something that we're going to need to get your feedback on as well, and really everybody, both the subcommittee as well as our guest feedback. We have here that the duration of both the law student and the law school graduate. Previously, it was set at the law student certification lasts for 18 months or until the results of the first bar exam after graduation are announced. And we changed that. We wanted to just kind of eliminate this 18-month or the first exam thing, because I think it has historically caused a bit of confusion. And so we just wanted to kind of streamline it. And at first we were talking about, well, perhaps it needs to be the third bar exam after graduation. That would be, typically students are graduating in May. There's the first one that following July, that's the first bar exam. Then of course there's the February one, and then another July the following year. But in my, I guess as I've been thinking about these rules as well as talking with some other folks, I wanted to bring this to the subcommittee's attention to see if really this should not be the third bar examination, but maybe the second bar examination. That essentially, folks, if they fail the first one, they get one more shot at it, and they would be allowed still to become a certified person or certified graduate. They could provide that limited supervised service just to maybe hold that place if they've been offered a job in a particular county, whatever it might be. But really, it's just kind of a one more shot, as opposed to giving somebody a full year, really like a 15-month window to actually continue to try and pass the bar. So I want to get everyone's thoughts on that as well. And then, of course, included the the notion that that yes, if once the certified law student or law school graduate, really, I think this is an addition for the law student, because this is the requirement to take the MPRE is already in the graduate section. But this is something that just came up about a week ago when I got a call from someone asking about if I have a certified law student who takes the bar and achieved a passing score, but they have not yet completed the MPRE, are they still allowed to be certified until the next MPRE is administered? And apparently the person missed the one that was most recently offered, so they have to wait till August to actually take the MPRE, which means they cannot, even though they passed the February bar, they cannot get sworn in until at the earliest August, when the next MPRE is actually issued. So this is kind of a tack-on additional issue since we are in the rules, and I'm going to need to get some feedback on this because in that situation, I don't know that really goes with the spirit of the rules, that this period of law student certification isn't really supposed to extend for a long time. It's supposed to be kind of, hey, you pass the bar, you can stay certified until you actually get sworn in. But that swearing in typically occurs within the next 30 to 45 days. But this, of course, this situation that presented itself would have the person, like in this situation, achieve a passing score on that bar exam in February and need to be certified for another 6 months just because they're waiting for the next MPRE exam. So I need to get some feedback on that, but that's why that is in there. Just a quick little background. Again, same sort of thing. We're talking about duration for students. We have to have a section for duration for law school graduates, and I need to get that third versus the second bar exam after graduation feedback from everyone. Everything else is as it was before. As far as supervision and so forth, nothing else was new. One thing that I did take out, there was an extra paragraph under activities last time that I think I had added it as kind of a placeholder, but felt like it was confusing and everybody else agreed. So I just took it out. It was never something that needed to be amended. It was something I added in as I was drafting this. And I think we all agreed that that wasn't helpful. So I took that out. It's not material. As well as this student practice placement section is something that I had previously deleted because I didn't know how applicable it really would be under these rules and if that's really even necessary. However, talking with Dottie Miani, who is our staff person that has been running the third year practice rules, or the student practice rule process for the past 20, 30 years, maybe 40 years, she said that she had hesitation of removing that and thought that there was still some utility in certain situations. So I just went ahead and left that in there. So you'll see that's why that was kind of undeleted, just leaving it alone. But those are the changes. So I think the things that we really need to talk about today focus on kind of the question of, do we like the definition of a law school graduate being somebody who, I'm gonna go back up here to it, who is attesting in writing that they are planning to take the North Carolina bar. The other alternative that we were discussing, and Lee, I would love your opinion on this. We talked about whether or not, instead of attesting in writing, should the person have a pending bar application? But we were worried that if we required a pending bar application, if somebody fails the July bar exam, is there a gap? Is there a 1 week, 1 month, 2 month gap until from learning you failed and your application essentially is kind of perhaps concluded to when they can actually refile and reapply. We want to know about that gap because perhaps the pending application is the way to go. And then, of course, I need to know what you all think about the duration of this certification, if it should last until the third bar exam after graduation or the second. So, Mr. Chair, I don't know where you want to start.
Let's start with, let's get Lee's opinion on where you are right there at D, the attestation in writing, or yeah, let's see that opinion.
Okay. First of all, thank you very much for inviting me to participate today. Really appreciate that. And I had spoken with Brian briefly earlier about some of these issues. And while I certainly cannot speak for the board members themselves, obviously, I haven't talked to them about this, but addressing the issue of whether or not to have them just simply attest in writing that they intend to apply, or requiring them to have a pending application with us, there should be no issue with regard to them not being able to access an application to file when they need to. The way that our current system works is we can only have one examination session open at a time in our bar admission solution software. Having said that, if you look at the deadlines for each of our exams, let's say you have a new grad in May, they want to apply for July. They will have already filed their application for July, because our deadlines for July are the first Tuesday in January and the first Tuesday in March, prior to the July administration. So those first-time graduates will have already applied. If you had a candidate who sits for July and is unsuccessful, they have a deadline of the first Tuesday in May to file for another exam. Same would go for February. If you were to have someone who needs to apply for the February exam, if they're a first-time applicant, our filing deadline is in October. The late filing deadline's in November. The only period of time in which our system will not allow an applicant to submit an application is from the middle of May until the middle of August. But there should be no examination applicant who would need to do that, because they cannot meet the deadlines to file. So they should have already filed for the exam that they need by that time.
Lee, can I ask a quick clarification? Just want to make sure I'm understanding this. So if somebody graduates in May, they're going to take the July bar exam. You know, just like you said, they've already applied during their third year, that second semester, third year. They failed the July exam. When they receive those results at the end of August, typically, as soon as they receive those results, they have the ability to, essentially go and apply for the February exam like that afternoon, if they're so motivated, I guess. Okay.
Correct. The session actually opens for February before results are released from July.
Okay.
So the February application window is already open by the time we release.
Great.
So there really wouldn't be there's no lag period. I mean, they could turn right around and apply. So
yes.
Yeah, there's no dead window, so to speak.
Lee, could I ask, thank you again, thanks for being here. The application for a second time taker, are they generally able to essentially transfer over what they used in the first one, or I'm trying to think of how long it might take them to complete a new application.
That's a great question, Peter. The supplemental application is, for all intents and purposes, to update the information from the initial general application that they file. So it is a much abbreviated version. They do not have, it does not take nearly the lead time to prepare and file as a general application. So
They don't have to
most
go out
of
and
the
get new
information-
references and get all those things filled out and completed and all that stuff. It's just update anything that's changed in the interim period, pretty much.
Yes.
Okay.
And so the process, the filing process for a supplemental application is not nearly as lengthy as your initial application, because we are simply updating it and supplementing it.
Great.
But there
Anyone
should
else
be
have
no
any-
dead time from a filing perspective. And if I could, I would have just, I would voice a little concern about only having them attest in writing that they intend to apply, rather than requiring them to have a pending application. Because my concern with that would be, while they may very well truthfully attest that at that moment they intend to apply, I would be concerned that what happens if they don't? And how long are they given to move forward with seeking admission? So that you won't have the risk of folks trying to utilize this program for something that it's not intended to do.
Makes sense. It makes sense. Anyone else have any thoughts on the testing and writing versus changing that language to having a pending application?
Lee, I do have one more procedural question here in terms of what they could use to show us that they have a pending application. Is there like a confirmation email or a confirmation thing that they get that shows, yes, we've received your application or something? So, I mean, I don't want them to give us their entire application, but if they have a way to be able to prove that it's been submitted.
And essentially, filing of the application is a two-part process. They will complete an electronic version of the application on our website by creating a secure portal account. They upload that electronic application, but in order for the application to be deemed filed under the rules, they must then submit a hard copy with the appropriate application fee by the deadline. So when they submit their application in hard copy with their fee, they are provided a receipt for that. Also, certainly we would be more than happy to assist by providing certification that, yes, this person has a pending application with us.
Okay.
So I guess the question would be that if we do, let's say they meet all the requirements for the certified law school graduate, they apply for the July bar while they're in law school, they come out, they do not pass, then if they don't immediately reapply, if we add that language, then there's going to be a window, whether that's a day, a month, however long, where they still wouldn't be certified. So do we need to tweak that a little bit, or is there like to avoid a dead period, if that's the language we put in, which I certainly understand the points, especially for the board of law examiners.
Yeah, I mean, I think we would want to have just, we could be reasonable here. I mean, it's like, if you get the results, you're not necessarily having a great day if you weren't successful. To expect someone to immediately that day submit something for February. I don't think that would ever be what our intent is to be that strict. So I think you might I don't know if there's a, like, if we need to put a clause in here about this situation, that if you're unsuccessful, you know, have a 7-day window to apply for the next bar exam or something, or within a reasonable time, or something like that, because, you know, they've already been certified, they're already certified in this scenario. How do, you know, how would we know that they were no longer, or how would we, tell their supervising attorney that they're no longer certified, by, you know, if we don't know, maybe we get a list at the deadline, like they have till the deadline, and we can get a list of who have applied, and those people would no longer be certified. I mean, that might be the easiest
Yeah.
logistical thing. It's like they have till the deadline to apply, and then they're no longer certified if they don't.
Anybody else have any thoughts on that?
I think as far as ease of policing, what Peter's saying, I think is probably the best route.
Yep.
Is if we have it till that deadline, because then we've got that knowledge. And
Right.
at that point it would end. I did have one question that I may have missed though. If I'm not taking the July bar at all, and I'm just gonna take February first time, graduating in May, when does that open up to apply?
That would open the August after the July preceding exam. So
Okay. So that would be the only other concern I have is, let's say I went to law school in South Carolina and Columbia and had intentions of practicing in South Carolina, but we run into this in the 5th district a lot. My wife or husband is a Marine, gets shipped off to Camp Lejeune, and I want to be able to practice. So I want to be able to apply for the February bar, but from June until the opening date, I wouldn't be able to.
Yeah.
I have
that's
a question. Is that to suggest that they are attesting in writing that he or she intends to apply or to reapply if unsuccessful within the time period of however many attempts they may have?
Well, I guess let me
Once we decide that time period.
yeah, let me first address Kevin's question. I think, and then I'll go back to yours, Judge. I think Kevin, your scenario would be addressed by, like, in your scenario, are you saying that that attorney is actually licensed in South Carolina?
No, I'm saying this person, say they graduate May 7th, whenever it is,
Yeah.
and we're scheduled to take the bar in South Carolina,
Oh,
which is
gotcha.
not going to have reciprocity, and they end up deciding to move to Jacksonville,
Right.
and they're qualified, competent, accredited law school, check all the other boxes, have every intent of taking the bar in February, but we miss out on being able to bring them on to a PD's office or a DA's office for 3 or 4 months at least, while they have to wait till it opens up.
That's
I
good
guess
point.
that's right. The May graduate that has a change of life circumstances requiring them to then apply for the North Carolina bar, but they have missed the July bar deadline, would have to wait until August. Would have to wait basically the months of May, June, and July before they can be certified, once they actually get their bar application pending. So, you know, whether that is that 3-month gap immediately after graduation is something that we need to address, or if that's just kind of that's just the circumstances. I mean, if somebody's planning to take the South Carolina bar and then life changes and they abandon that, I don't know how many folks we're gonna be running into that would be looking to start work immediately during the months of June and July when they're changing that. But I don't know, I could be wrong there. But it would create that gap. It would create that gap that somebody who cannot apply or did not apply for the North Carolina bar by the deadline upon graduation, they would have to wait till August because that would be the next application period where they would be eligible to get a pending application in.
And it seems like that's where the attest and writing would solve that problem versus the pending application. So
It would like the attesting and writing is clearly more flexible and more I guess it has less clear defined parameters. Like Lee said, somebody can intend to apply at that very moment, and then the next day after they filed that, realize I actually am changing my mind. I want to go down to Virginia, but I've got this job, and I want to do that for the next 6 months, and then I'm gonna while I also apply for a different bar and do that. And that's, again, we start kind of, you can contrive a bunch of different scenarios that we wouldn't want. And I don't know with these rules, just what we want to protect against more, or accommodate. But yeah,
Well,
clearly,
the other part of that is something that's comparable is when someone is applying for comedy admission. Our rule requires that they have a pending application, a pending comedy application with the Board of Law Examiners. And we don't say that they, are moving here and intend to apply with the Board of Law Examiners. We say that you've already done it. You've submitted that and you're practicing pending the comedy admission. There's nothing that stops one of the, DA's offices from hiring that person as a legal intern or a legal assistant until that window opens up for them to submit that application to be able to do more of the certified or the supervised practice part of it. I'm worried of throwing out the baby with the bathwater, trying to figure out an answer to every scenario when we, I tend to agree with this idea that we're trying to encourage North Carolina, people to become North Carolina lawyers. And one way to do that is to make sure that they're applying for the North Carolina bar exam. And so I don't know if there's a workaround for Kevin's donut hole situation that someone might be in, but I would want to encourage us to consider keeping that pending application part of it as much as we can.
makes sense.
Yeah, my 2 cents is I agree. I like the pending application portion of it better than just the attestation and writing. Would there be, Peter or Brian, would there be some way we could build in, a special circumstances way somebody could petition? I can't. I mean, Kevin's point's a good one. But we could have some way they could apply and petition for hardship, maybe is what you call it, in a situation like that where they could still do it. And we could get some affirmation from them or attestation that they intended to apply in those special circumstances. I don't know. Maybe that's some type of workaround, like you mentioned, Peter.
yeah, I mean, I think it is possible to write that in. There's a part of me that also is just looking at this and saying, we, like Peter was saying, we can try to think of all the different scenarios. We might need to see how these things operate, to see where what if since we've all thought this is a good idea, if we just kind of get the shell in first, or I guess what we think is the best version of these rules first, and then see where are the pain points. But I understand there may be a need for reasonableness and I don't know how we necessarily codify that. But still, it's something that I think we need to keep on our radar.
Would anybody necessarily be opposed to changing that language, the highlighted language that's on your screen from the attested in writing that he or she intends to apply to basically taking that out and adding a pending application? Does anyone have any, I understand Kevin's scenario, but any strong opposition to that.
Not really. I prefer that, honestly, the pending application. Because that's why I suggested the attestation to begin with
Right.
was if it was just a period of time, they never even had to register.
Yes.
So I prefer the pending application. I would just, it would be good if we had some type of an exemption process at some point.
Okay. So let's,
Well, could you,
go
to
ahead.
capture those that may have life happening or who are repeating, to say that who has a pending application or intends to reapply, or something that gives that covers that window between attempts, so that they're not subject to their agency or giving a subjective reading to what this language is. I mean, we're having a little bit of trouble with it
Yeah.
ourselves, but
Yeah. Could be some sort of a pending application submitted prior to the deadline for the next bar exam, next available bar exam or something like that. Like, that they have put it in, because I definitely don't want there to be a gap, and that might help a little bit in Kevin's situation, because then they have until that deadline for the February exam to get that in. If they've missed the deadline for the July one for whatever circumstance.
so would that be 3 scenarios: that the person has applied, intends to reapply if they have been unsuccessful, or intends to apply if they have, I don't know if you want to say this, but come to North Carolina after the application deadline?
Well, I think each time would just be the next application deadline. So I
Okay.
don't know that you have to
The
put
next-
in
just
3
say the
different
next
options. It would
application.
just be one
Okay.
thing, that you have a pending application in prior to the next application deadline, prior to when you're seeking, or after you seeking certification. So if you're seeking certification in June,
Well, can I jump in here? Because
yeah,
I
please.
think there
Yeah,
is I think there is a solution, and
Okay.
the solution, I think, is the withdrawal of certification. Because we can simply say that, clearly, if somebody's going to apply for certification, we're saying they have to have a pending application. That covers the folks that are applying for certification while studying for that July bar exam. We can allow that certification, if they do that, we can allow that certification to continue if they don't meet the criteria to have their certification withdrawn. And that's where we can write the language, write a new clause in this section to basically say that withdrawal of certification can occur if the person fails to, after an unsuccessful attempt at the bar exam, file a new or reapply to admission to the North Carolina State Bar by the deadline set by the Board of Law Examiners. I think that that's one of those things that we would then need to, again, based on the waiver of confidentiality that we would ask the applicant to sign, we would need to communicate with the Board of Law Examiners to see if anybody who is certified and is in that very scenario has not applied, because then we would have to revoke their certification. But I think that could be something. And of course, if somebody does not apply for certification until after they have learned they failed the bar exam, I think even then it's still okay to say you have to have a pending application. If you have failed the bar exam and you aren't certified at this point, now you're trying to get certified, well, you better get your application in so we know that you are actually still planning to reapply. So I think that could still work. We'll put this concept of covering that dead period between learning of the unsuccessful attempt and reapplying in the withdrawal certification. Does that work for everyone?
I think that works, for at least from my understanding of what you were saying. I think that works. Anybody else have anything else to add on that?
I agree with that.
I think that's a proper solution. It also helps with enforcement. I'm kind of worried about enforcement on this, and that is a simplistic way to enforce it.
All right. So let's then what I'm hearing is we're agreeing to do the pending application up in D where we were, and then adding a paragraph in there where you're working at now about the withdrawal. Okay.
Yep. I'm just
All
gonna
right.
put a little placeholder here just so I remember that,
Perfect.
but I think that's what we're talking about here.
While you're putting that in, what I saw is the next issue we needed to really look at was whether it's the third or the second bar exam. That would be under the duration. Starting at the duration, there's 2 points of it.
That's right. That's right. And so yeah, let's talk about the duration, because I'd love to get your feedback on this. Like I said before, this is where we're talking about how long should certification last? Should it last for just to cover one unsuccessful attempt, but allows the person to be certified through the February bar exam? And I'm going to just stick with that as like the general timeline. I know some folks might graduate in December, first take the February, then take the July, but we'll just go with that. The point is, do you get 2 cracks at the bar exam before you're ineligible for this certification, or should you have 3? That's the big question.
And
One of the questions I've got at the outset, I'm sorry I was late, everybody. I had another meeting that ran over. But what does the empirical data show in terms of the success rate of second-time test takers and passing and third-time test takers and passing?
I might be able to speak.
Yeah, thanks.
That just-
Please do, Lee.
I will admit, I don't have exact numbers for you right here, but I can tell you definitively the pass rate declines precipitously after the second exam administration. The farther removed the applicant gets from graduation, the lower the pass percentage.
Interesting.
That's not surprising.
Right. It's just, the more time that elapses between the time that information is fresh in the applicant's mind and they just finished their legal education, the greater the time between that and the exam that they take, the worse they do.
Okay.
So Lee, to say it another way, this is my way of trying to think clearly about this. Are you saying that an applicant's best chance at passing the bar is really the first or the second exam, not necessarily the third, fourth,
Yes.
fifth, all that stuff? Yes. Okay.
Yes, the pass percentages are the highest the first time they take it or the second time they take it.
Okay.
From then, it begins to decline. And the farther removed you become, the more precipitously the decline.
Okay.
does anybody have any other thoughts about third versus second? I guess I was leaning towards third based on our last conversation, but now that's a kind of interesting statistic.
Greg, if I can, I was going to ask Billy and Nicoya about their thoughts, because I know, and I talked with Deontay Thomas earlier this week, who's I think he's the head of the Conference of Public Defenders this year, and just about kind of practically, how do y'all use this, Billy and Nicoya, when you are, like, if you're in that scenario where you have somebody who you've offered a job to, they failed the bar exam, but you want to keep them kind of in the office, and they can still contribute while they study for that next bar exam. Kind of, I guess, just keep that momentum going so that hopefully they will pass it in February and they can take their job. Is the second bar exam enough, or would you actually keep someone on for a third bar exam? I don't know if that was something that I know Deontay and I talked about, kind of what he would imagine in his office, but I would love to hear your thoughts as well.
Hi, everybody. I'll go first. Again, Nicoya Dobson, public defender in the 5th District. In my office, I would love to just see probably the second time. This, again, thank you for the opportunity to speak on this topic. This article would be so advantageous to our office in the sense of the test taker initially will not be employed. You know, we wouldn't even consider hiring them until after they would have taken the bar exam. And so they would, in an ideal world, they would start in August of that year. And as we all know, the results come back somewhere towards the end of August, beginning of September. If they were unsuccessful, then of course we would want to still keep them on, because ideally under this piece, they could have started practicing with supervision. And then in February, they would take it and hopefully the results would come back at March. By then, I don't believe that we would be in a position to continue to keep them on past that. We would want to, but realistically, we have likely already passed over other applicants and would probably need someone to fill that spot and to handle those cases by that time. And so for what it's worth, I would say, or ask the committee to consider maybe the first and second time as opposed to a third time.
Thank you.
And
Mr. West?
Yeah, I would jump in and say I could really agree with either. I mean, we had a success story in our office that this would have directly applied to. Young man, we offered a job. He didn't know. Everybody really liked him. He didn't pass the July bar, unfortunately. He actually was a South Carolina kid, but he really wanted to work in our office. We had a temporary position dealing with the e-courts rollout that I'm sure you're all aware of. And we were able to put him in that position, and he was very helpful, saw that he was going to be a good employee. The success story is he passed the February bar, and we are very excited that he'll be starting here with us in a couple of weeks. So to have had this provision in place that have allowed him to continue under basically, you know, what we commonly call the third year practice would have been great. He would have been able to do even more during that interim between the two bars. I certainly understand, you know, there can be a limitation on how long you can sort of quote unquote hold a spot for a person. So I don't have a really strong opinion about the second or third. I mean, this young man, we probably would have tried to find a way to keep him with our office until we had an opportunity to take it again in July. But, you know, that might be a little bit of an exception instead of the rule. But we certainly, and I think I speak for the Conference of DA's executive committee and our whole group for saying this would be a really good provision for us, whether it be through 2 or 3 bar exams.
I'm going to jump in and maybe suggest we make it third, but leave it in the discretion of the supervising attorney. You may have a situation where, like Billy said, an outstanding kid, maybe he had another bad day in February and they really wanted to keep him around. It would be, I mean, we would leave that door open, but if the supervising attorney says, look, this is just not working out, then that would be the case, because we are talking PDs and DAs here, and they can make that decision that this is just not working out. And then the burden would be on them to let us know they're no longer with the office. I understand that aspect, but I think maybe leaving that for those rare exceptions of, you know, everybody has bad days kind of situation, maybe 2 in a row. And that would be
So not more than 3.
Correct. Not more than 3. But, you know, to go to Nicoya and Billy's statements, you know, maybe after the second one, it's just not working out. You're not going to be a good fit. Maybe it's a great fit, and maybe with a little help, they do it on the third one. That's my thoughts.
Is that not more than 3 in the discretion of the supervising attorney's office or something to that
I think
effect?
it's always already in the discretion of that
Right.
supervising
Yeah.
attorney's office. I mean, if they no longer have them there or think that they can do it, then that's already in the withdrawal of certification part. So, be
So you
interested.
leave it at
Yeah.
not more than 3?
Yeah, I think you just leave it at third based on what Matt's saying.
So can I ask the question that I don't know if this is a difficult question or what, but the notion of someone being allowed to offer legal services after failing 2 bar exams, is that sending any sort of, I don't know, I don't want to say sending some sort of negative message or what have you, but I guess I'm just, I want to make sure that we're exploring this fully, and saying, yes, somebody can continue to offer legal services after that February, the unsuccessful attempt in February. They're going for their 3rd time, but they can continue to offer legal services for the state through the DA's office, or for an individual through the public defender's office or legal aid office, after failing twice before. Is that a message that?
That's a solid point, Brian. That's a solid point.
I don't, I'm not saying, I don't want to advocate for like one side or the other. I want to vet it.
And it is something to consider as it relates, and I'm sure, Lee, you might have an opinion. Like we have determined the bar exam is our gatekeeper. Part of the gatekeeping for the profession is passage of that to show competence. And if we now have 2 exams of evidence that hasn't happened, is there a public protection issue there too?
And I would say I agree, as far as I think having 2 attempts is more than reasonable. Everybody has a bad time, or everybody, for numerous reasons, may not be successful the first time. But I too would be concerned about, does that dilute, or could it be seen to be diluting the standards we've set? We've basically said, to show competence, you must pass the bar exam. If the folks were allowed to continue to represent people, say in legal aid, after demonstrating twice that they didn't meet the competency standard, is that sending a message that certain segments perhaps may not be receiving legal representation that's at the level that they should? That'd be my only concern. About saying 3rd rather than 2nd.
And Lee, I would say that's underscored by what you mentioned earlier, where the chances of success the 3rd time around decline precipitously.
And I'm certainly not trying to voice my opinion or anything will influence the committee, but I would be concerned about that.
And hearing those comments, I could live with the 2nd. I will say, here in Rowan County, small county, I know we had in our DA's office, we had an applicant who failed the bar exam, and she was working with the DA's office, and they had to let her go. Under this rule, she would be able to continue. The real question for a small town like here, while I'm not sure Ms. Cook would keep somebody if they failed twice, but their applicants are not knocking down our door where we have to pick one. We're taking the first, and I don't want to speak for her, but in speaking to her and talking to her, I mean, she's doing everything she can to get people to come here. If we left it at 3rd and did leave it in the withdrawal, or her saying, hey, you didn't pass it in 2 times, sorry, we can't continue, I'm moving on. It does allow for a smaller district, or a legal desert, as we spoke about previously, to be able to have that option. I agree with what we're doing, the perception with the public, but also have to look at that. I see Ms. Dobson has her hand up. Yes, ma'am.
Mr. Jones, you are exactly right. And I wanted to, I sent Kevin a message because we too obviously are in a legal desert. So this is going to help us out tremendously. But the reason why I said the 2nd time is just from a funding standpoint. We are in IDS funds. And so, not to get too deep for this meeting, I just know that I'm not sure that I would have the continuous funding if that person doesn't pass. I think I'd have a hurdle to jump for the first time, but certainly the second time. So it's not that I wouldn't be advocating for a good applicant or someone that has shown from a practical standpoint that they would be a great asset. It's just the funding. And so, like you said, I just hired my last attorney for this position, and we've been in existence since last year. And this provision would have been amazing if we could have used it, because that's now a year and a half. So I just wanted to put that out there, that we too are a legal desert, but I'm thinking in terms of funding, which is another hurdle that, would have to come. I would have with yes.
Well, I'll say I agree with what everybody said, and I could probably go with two, a second or a third. But if Brian, to your point, I think it's a good one. But if we set a third, aren't we still leaving it in the supervising attorney's discretion? But they're the ones working with them every day. They're the ones that can decide if this person just is a bad test taker, if this person really has the skills that are going to be necessary to be a lawyer. They just, for whatever reason, have flunked twice. But a supervising attorney could still give them that chance to go to the third, or maybe not. Maybe like you said, Greg, maybe Brandy or any other DA or supervising attorney would say, I'm done. I got to move on. I got to hire this position. But at least we're giving them the opportunity to allow the supervising attorneys to make that decision, who are working with these people every day.
Yeah, that's the reason I would lean towards a third, just because we have that safeguard, so to speak, by the supervising attorney.
Right.
And to support what Jay is saying, if the person stays on for, say, a third year, then the supervising attorney would have the discretion to change the duties of the graduates, so that perhaps they're not doing what is tantamount to representing clients, but performing some other duty in the office close to what a paralegal would do.
Right. Yeah, you all are absolutely right. There is a supervision component that is an actual attorney making the call on what is and is not appropriate, and whether somebody should or should not be in the office. So,
with us getting right here at the 2:00 hour, let's finalize at least the second or third. Do I hear a motion from anybody as to one or the other?
I move the third examination.
I hear a move for the third and a second. Any more discussion? Any more discussion about that? All in favor of that one, if you'll, the easiest way is indicate by aye. Any opposed?
Yeah, I would keep it at 2, but that's just my opinion.
Right. So at this point, based on our vote, I would say take it to third on both duration, and I think it's the same under B1 as well. And then again, whatever we send, we're sending it to the issues committee, and it's going to go out for discussion. I mean, some of this could have further discussion later on anyway. So
that's right.
Was there any other? What was you explained why you put that paragraph back in?
Yeah, that was just something to address the situation that we were recently presented with, where a student was certified student was trying to extend their certification. They passed the bar, but they had not yet taken the MPRE yet. And of course, there's nothing in the rules that requires a student to have obtained a passing score on the MPRE. It just talks about being sworn in. So, in theory, somebody could, and I guess, Lee, I actually thought that folks did not get their bar exam results until they submitted a passing MPRE exam. But yeah, so I guess you could get your results and find out you passed the bar, but you just didn't take the MPRE, and in theory, just have that, since you can't get sworn in until you get the MPRE, you could stay certified for a long time without getting sworn in. It's kind of a weird thing.
Under our current rules, applicants have a 3-year window within which to take and pass the MPRE.
Okay.
They can sit for the MPRE up to 2 years before they sit for the bar, or within a year after. But they're not eligible for licensure until the MPRE pass score is certified.
So what this addition on your screen does, basically it addresses that situation where a certified student has obtained a passing score on the bar exam, and they are allowed to remain certified and basically start working right then, because of course being sworn in and getting your results, there's that gap, 30, 45 days, it's not terribly long, but it's still meaningful. So that's what the rule intended to cover. But I put in here that the certified law student can only take advantage of this coverage if they have obtained a passing score on the MPRE, as opposed to allowing them 3 years of certification potentially while they maximize that window on passing the MPRE.
Gotcha. So it's not like a repetitive statement from earlier. It's yeah, I see the purpose of it now. To me, it just looked like something that was repetitive from before. But
Yeah.
Anybody have any strong opposition to that being in there?
I have one question. It does say right before that proviso, and admitted to the bar. So wouldn't you necessarily have passed the MPRE to be admitted?
So I guess the certification is going to remain in effect until they are sworn in and admitted. I guess that's kind of saying like sworn in and admitted being really like they're really kind of using those terms synonymously, saying that like the certification remains in effect until you are sworn in and admitted, provided you've actually obtained a passing score on the MPRE as well. So that's where it's just adding that component to not only do you have to get a passing score on the bar exam, but you have to actually get the MPRE. I think that the language that you're referring to is just kind of referencing this coverage, this gap extends until you're sworn in / admitted. That's how I read that.
Anything else on that particular point? Everybody in favor of keeping that language in at this point? Or let me put it this way, anybody opposed to that language remaining in? I would say that at this point, no one's opposed. We'll leave that language in. Those were the main topics that I recall. Brian, is there anything else right this second?
There's nothing else. So I think we've covered the main points. So this would be something, I think, if the subcommittee agrees on these, and then you can report that at the issues committee. If you wanted to take a vote now, you could, as to whether this is an approved set of rules. But again, this would just be something where it needs to be reported to the issues committee that these are rules that the subcommittee feels are appropriate for sending to executive for publication.
So understand that we would if everyone is comfortable doing that, there is one caveat. Brian will be adding a paragraph under the withdrawal of certification.
Yes.
That right now we do not have, but we all understand what that's going to be. So would this committee or the subcommittee choose to wait for that, or are we comfortable with what we have proposed at this point to present to the issue committee, basically recommending the adoption of the law school graduate practice rules as we have written with the added paragraph, which I'm sure Brian can send out to us and we can see before.
I'll send an updated version of the rules. So I think, and that's where I think procedurally, y'all are good either way.
Yeah, I don't know that you actually have to have a motion to adopt or recommend these exact rules. You could just say the rules as we've been working on, that would be brought to the issues committee with the recommendation that the committee the issues committee move forward with presenting rules to allow law school graduates to have supervised practice to the executive committee. Like, I don't think they have to be fully done today.
Okay.
Because you'll have a vote in the issues committee on this stuff anyway. So if we bring the
Right.
rules, you'll have an ability to discuss those and approve the rules that are going to go to executive at the issues committee.
So the subcommittees that are here, is everybody in agreement? This is a proposal. We said earlier we wanted to move forward with this. Everybody comfortable with making that making that recommendation at the issues committee come April? 2 weeks away?
Yep.
Anybody have an opposition to that?
No.
All right, we're past our 2 o'clock hour, or the 1 hour mark. I want to thank everyone that joined us, including our guests today. I think that was very valuable, Lee. We appreciate everything, as well as from Ms. Dobson and Mr. West. Those were good insights that helped us, because a lot of that's the same type of thing Ms. Cook's experiencing here. So appreciate everyone being here. Does anyone have anything else that they want to bring before the subcommittee before we adjourn? The way I see it is our next steps, then we'll present this to the issues committee come April. Appreciate everybody's work. If anybody has any questions, I'm sure you can reach out to Brian, Peter, or myself, and we'll try to address them.
Thanks so much. Appreciate you having us.
Yeah, I
Thanks.
appreciate it very much for you being here.
Lee, could
Thank
you
you
hold
for
on
having
one
me.
sec so I can ask you a question?
So long, everybody.
Okay.
All right.